Want to see an idea not only get laughed at by normal people, but get shot down and thrown out of court as well? Well, today I got a treat for you, and it's in the form of number 3 here. Now, when you read number 3 in legal terms, basically a judge restating a question so that they can answer it, it doesn't come across as so absurd. Whether defendant has alleged sufficient facts to state a claim for the violation of the Virginia Computer Crimes Act. Doesn't sound so bad, does it? But when you get into the reality of what's being stated and subsequently shot down here, the idea that millions of users are not real people. When they post on Twitter, that's not their thoughts. When they post videos on YouTube, that's controlled by another person. When they sign things like change.org petitions, no, that doesn't count either. It all leads back to the plaintiff in this stuff. That's the person pulling the strings. Yeah, you can understand why people would laugh and laugh and laugh. Now, what makes this even better, too, is the fact that it doesn't fall apart because of the absurdity of that. No, that's just a bonus. The reason it falls apart is because the people that are saying this, they don't even have a basic grasp of the laws that they try to communicate. You're going to love this stuff. It's so good, so make sure you tune in right to the end. So hey there to all you fine folks, by the way. I hope your afternoon is going splendidly, but more than that, I hope 2021, it finds you kindly. Now, I'm going to ask you to share, comment, feed that algorithm, and check that you're subscribed too. Like the content, subscribe to the channel, check into other videos. You know how that thing goes. Now, before we get into this is really important too. I'm going to suggest 3 documents to you. So if you want to review this on your own, and I would suggest that you do, you can look at this and you can build your own opinion. This thing, it feeds off number 1, counterclaims. Counterclaims, it's proposed by a certain person. I'm going to call them a nameless party. Thank you, platform, by that. And what they're saying, they're asserting counterclaims against plaintiff, against JD. Now, our second document that this feeds off of, this is from demur and plea and bar to counterclaims. This is filed by our plaintiff, JD, to the defendant, certain nameless party, asking specific questions. And finally, we have an answer to all of those questions in the form of an opinion letter. You can see that stamped across the bottom here. The opinion is handed down by our legal authority on this matter, aka our judge. Now, as far as what this thing is answering, there are 5 questions here. And these 5 questions, they basically deal with the idea that a certain nameless party, they can bring litigation against JD. They can, by the way. The judge pretty much lays that out. I covered that in a video yesterday. What I didn't cover was the laugh track hidden in this because it deserves its own video. And that, it deals with opinion number 3. Whether defendant has alleged sufficient facts to state a claim for a violation of the Virginia Computer Crimes Act. Now, cutting out the legalese, this is what it's answering. This stuff is golden, too. Excuse me for laughing there, but the absurdity to all of this, I'm glad that it's pretty much become a judicial laugh track. So basically, what this implies is that from 2016 on, the plaintiff, JD, has been aiming at that certain nameless party's career. And the way that he's been doing this, well, listen to this here. To accomplish this task, he individually, or through his representatives and agents in Virginia, has created, coordinated, controlled, and or manipulated social media accounts created specifically for the purposes of targeting that nameless party, computer-controlled social media accounts, and or groups of inauthentic accounts controlled by a single agent to amplify content misleadingly. Now, to translate that, people aren't people. Oh no, they're bots. You are a bot. You're controlled either by the plaintiff in this or by his lawyer. How do they know that? Well, let's continue here. These accounts exhibit behavior which includes but is not limited to the following. They have high tweet to retweet ratios in numbers implausible for authentic human users. They are created, attack that certain nameless party, then are set to inactive to avoid suspicion. They utilize common language patterns and timing indicating broad coordination. They often offer little or no personal information, suggesting computer control or a single individual controlling more than one account at a time, and often many more, and they republicize the content of one another at rates and consistencies that belie authentic human control. Basically, you don't say who you are online, you don't have enough followers, you tweet too much, you retweet people that we don't like, so therefore you are a bot. Now, I'm skipping and summarizing points, but I want to include them because these things are hilarious. There's 3 more to go. This one, it talks about change.org petition and signatures. Look how this comes across. The use of fake signatures on this petition, so they're saying those signatures are fake, millions of them, are outside the skill set of your average internet troll or disgruntled fans. Basically, my consumers are dum-dums. Man, that is a smart way to go. Way to back that thing, Warner. Now, the last 2 parts, they're combined here, but man, they deal with some of my favorites. This first part, this is so good, by the way. It answers what kind of bot you are, and what kind of bot do you think you are? Well, let's check this out. There are a number of newly created foreign language accounts, specifically or predominantly designed to damage that nameless party. Many of these accounts have what kind of signature now? Reflecting where's that origin? Oh yeah, you're a Russian freaking bot. Then they want to go on to tie his attorney, Mr. Waldman, into the Russian thing. You notice this. Mr. Waldman is publicly associated with Russian individuals with the capability to organize such attacks. Now, after that, they go after specific users. There's a lot of users named, but the 2 that they'd put the most blame on, well, we'll hit this part and then we'll hit everything else. So 2 accounts, they give you the accounts here, are responsible for approximately 50% of the targeted attacks on that nameless party. The My Grindelwald account uses its platform to amplify that anti-nameless person hashtag and false information being disseminated about that nameless party. It also amplified change.org petition described above, repeated calls for that nameless party to lose contracts or business expectancies, and as evidence of its origin, it routinely tweets the statements of the JD's agent and attorney, Mr. Waldman, on a near-daily basis, and often praises the otherwise unknown attorney, even going so far as to say, "I love you, Waldman." So that it pretty much summarizes everything there. Again, I would say that you need to read that on your own. Apologies for laughing so much. I tried not to, but the absurdity here. I imagine an Intel sign coming up for all you bots, but instead of Intel inside, you have Russia inside. But anyway, so this is what the court has to say. You can see her opinion letter here, and the demur to count number 3. That's basically, you have the plaintiff answering that. It's sustained. So they're saying, yeah, that's pretty much absurd, isn't it? So under the Computer Crimes Act of Virginia, or the VCAA, a claimant must prove, number 1, the person used a computer or computer network to, number 2, communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or make a suggestion or proposal of an obscene nature, or threaten any illegal or immoral act with 3, the intent to coerce, intimidate, or harass another person. So you have to meet all of that there. None of the nameless party's allegations satisfy all 3 prongs of the VCAA. I wonder how many prongs they actually meet, though. First, the nameless party has alleged that JD used a computer or computer network in 4 instances. And you'll notice text messages mentioned in this stuff. Text messages are basically sent to a friend. They were angry text messages, but yeah, anyway. So when he initiated, coordinated, oversaw, and or supported and amplified 2change.org petitions, when he created, controlled, and or manipulated social media accounts, when he texted Mr. Bettany in 2013, when he texted Mr. Carino in 2016. Look how far back this stuff is, too. Oh, he was trying to go out and ruin me in 2013. Right when we were having our relationship, well before we got married. Yeah, that really goes in there, right? And oh man, he was trying to ruin me in 2016 when he was angrily talking about me in very derogatory fashion. Now, this court now examines each of these instances to determine whether they meet the other 2 VCAA prongs. So our 2 prongs here. The allegation that JD has initiated, coordinated, overseen, and or supported an amplification of 2change.org petitions. 1 to remove that nameless party as an actress in the Aquaman franchise, and 1 to remove her as the spokesman of L'Oreal, fails under the 2nd prong of the VCAA. Nothing in that allegation implies facts showing that the Change.org petitions included obscene language, threatened illegal or immoral acts, or suggested or proposed obscene acts. So that it's funny in and of itself, because it's saying even if that person did it, even if Russia was actually involved, it doesn't really matter because it's not proposing what you want to propose. Bravo there. Bravo. You not only threw out one of the most ridiculous ideas, but you didn't understand the basic tenets of the law that you were suggesting. Likewise, it continues, the allegation that JD created, controlled, coordinated, and/or manipulated social media accounts created specifically for the purpose of targeting that nameless party also fails under the second prong of the VCAA. The pleading fails to demonstrate that the social media accounts communicated obscene language, suggested obscene acts, or threatened illegal or immoral acts, because neither of those allegations meets the second element of the VCAA. They cannot move forward in this litigation. Again, you go out, you burn millions of people for a company. You burn them individually as well, saying because they think this, well, they're not real. They don't matter, and it doesn't even meet criteria. Isn't that hilarious? Like I said, it's not only a laugher because of what it's shooting down, but it's a laugher because it doesn't understand the basic subject that it's talking about. Now, the remaining two things here, they allege computer usage fell under the third prong of the VCAA because that nameless party has not alleged that they were made with the intent to coerce, intimidate, or harass. Rather, it appears that JD texted those statements privately to two of his friends, and the nameless party has not alleged that JD intended for her to see them. Accordingly, the court sustains that with this third part as well. Now, the most hilarious thing about all of that to me, outside of imagining the judge reading this and thinking, what the heck is going on here, is the fact that they spent so much time trying to make that point. It was one of the heaviest points they tried to make, and they didn't even understand the basics to it. So you have bridges burned for Warner, quite a few there. Bridges burned for other companies like Disney. Bridges burned for an individual, saying people don't matter again. And yeah, that amounted to absolutely nothing. But anyway, let me know what you think about this stuff. I think it's absolutely hilarious. I think this is a judicial laugh track worth applauding. Good stuff there. Good stuff indeed. And make sure you check out the other video talking about everything else here, because you will see a lawsuit coming from the nameless party toward JD. You watch, it's going to come up, and it's going to come up pretty soon. But anyway, let me know what you think about all of this stuff. And as always, appreciate the heck out of you. You make this stuff possible. Can't say that enough. Also, want to help out the channel? There are links in the description. We have quite a few of them, and we could definitely use your help. Patreon, PayPal, memberships, merchandise, and of course, our luscious comic book. But anyway, I appreciate the heck out of you being here. You make this stuff work. And yeah, I'll see you soon. Make sure you leave comments too. Feed that algorithm. Make sure you're subbed if you like the channel as well. Thank you.